The Supreme Court has just initiated a constitutional sequence that could effectively erase firearm permit requirements from the map of all 50 states. But what has transpired in the last 48 hours is absolutely unprecedented in the history of American jurisprudence. The Department of Justice has not merely filed a brief supporting this challenge. They have kicked down the doors of the courtroom and are now demanding a seat at the table during oral arguments to personally spearhead the execution of these permit systems nationwide. This fundamentally alters the battlefield for millions of gun owners across America. If you are not subscribed, you need to hit that button immediately, because the legal tidal wave that is approaching will impact every single gun owner in this republic. The emergency petition that stunned the legal establishment. The Supreme Court is inundated with thousands of emergency petitions annually, yet they grant fewer than 1% of them. When you narrow that down to Second Amendment cases, the acceptance rate drops to near zero. The court had summarily denied every single emergency gun rights petition for the past 3 years. That is the context that makes this decision so earth-shattering. When the plaintiffs filed this emergency application, the vast majority of legal scholars gave it a statistical probability of 0. The conventional wisdom, the comfortable lie told by the establishment, was that the court would force this case through the slow, grinding gears of the normal appeals process, a delay tactic that could have frozen your rights for another 2 to 3 years. Instead, the court granted emergency review within 48 hours of receiving the Department of Justice's supporting brief. That timeline is not just fast, it is nearly unprecedented for a major constitutional rights case. What very few people realize is that only 8 justices needed to agree to hear this case on an emergency basis. However, leaked internal court documents suggest the vote wasn't even close. The velocity and unanimity of this move signals something massive is happening behind the velvet curtains. Chief Justice Roberts, a man who typically urges caution and delay on emergency applications, reportedly threw his full support behind immediate review, according to sources deeply familiar with the deliberations. The court's docket was already bursting at the seams. Yet, they forced this case onto the schedule, bumping other arguments to accommodate the urgency of this constitutional crisis. Supreme Court clerks reportedly worked through the night processing the emergency petition paperwork, an event so rare that insiders say it happens perhaps once in a political generation. But here is the smoking gun that nobody in the mainstream media is reporting. The court didn't just agree to hear the case. They specifically issued an order commanding both sides to answer one terrifying question. Did historical permit systems even exist at all during the founding era? The 21-state regime now facing extinction. Currently, 21 states maintain some variation of a permit requirement that acts as a gatekeeper before citizens can purchase or possess firearms. We are not talking about concealed carry permits here. We are talking about permission slips required just to own a handgun inside your own locked home. Massachusetts mandates a firearms identification card that extorts $100 from citizens and takes up to 40 days to process. 40 days during which your Second Amendment rights are effectively suspended. New Jersey's system is even more draconian, with average wait times ballooning past 90 days and application fees reaching $200 once you factor in the mandatory state-approved training costs. Illinois operates a firearm owner's identification card system that has seen processing times explode to over 120 days in recent years. That means citizens are forced to wait 4 months just for the government to grant them permission to exercise a natural right. The total number of Americans living under these bureaucratic permit regimes exceeds 60 million people. That is nearly 1 in 5 Americans who are currently treated as subjects rather than citizens, forced to beg for government approval before owning a firearm. What makes this litigation even more critical is that several of these states explicitly engineered their current systems as loopholes to bypass the Bruen decision, gambling that the Supreme Court wouldn't have the appetite to take another gun case so soon. Connecticut went so far as to pass emergency legislation specifically to entrench permit requirements while claiming compliance with Bruen, a strategic gamble that now looks suicidal. Rhode Island doubled down on their permit system just last year, piling on more restrictions despite watching their neighbors get sued. The financial capital these states poured into upgrading their permit processing systems could become completely worthless if the Supreme Court rules against them. Some states spent millions of tax dollars on new software and database systems designed to streamline these unconstitutional applications, investments that could evaporate into thin air overnight with a single adverse ruling. The historical record that obliterates the permit argument. The brief filed by the Trump Department of Justice includes historical research that the permit-clinging states simply cannot refute. The data is damning. From 1776 through 1891, exactly 0 states required permits to purchase or own firearms. Citizens could walk into any general store and purchase a rifle with the same ease as buying a shovel, a hammer, or a sack of flour. The first permit law did not rear its head until 1911 in New York. And historians have documented, in cold print, that it was explicitly designed to prevent Italian and Irish immigrants from arming themselves. It was a law born of bigotry, not safety. By 1938, only 6 states had adopted any form of permit requirement. The vast majority of the current permit systems were enacted between 1960 and 1990, a period the DOJ argues falls well outside the historical tradition relevant to constitutional analysis under the Bruen standard. Even more compelling, the DOJ brief presents irrefutable evidence that the founders sold and purchased firearms through newspaper advertisements, without the slightest suggestion that buyers needed government approval. James Madison himself, the architect of the Constitution, purchased firearms through mail order. If permits were a valid part of our historical tradition, you would expect to find them in the founding era. They simply do not exist. The DOJ even unearthed colonial-era laws that explicitly protected the right to purchase arms without government interference. Historical records show that during the Revolutionary War, the Continental Congress actively encouraged citizens to purchase firearms without any permitting process whatsoever. The brief includes high-resolution reproductions of actual newspaper ads from 1776, showing firearms being sold openly to anyone with currency. Even more damaging to the state's case, the DOJ uncovered legislative debates from early state constitutions, where lawmakers specifically rejected permit proposals because they were viewed as incompatible with natural rights philosophy. What the states are now scrambling to defend is whether a handful of post-Civil War regulations that nobody has ever heard of can justify the modern bureaucratic nightmare they have inflicted on gun owners. The judicial civil war that forced the Supreme Court's hand, the only reason the Supreme Court was compelled to intervene in this specific moment, is because the federal appeals courts have created a state of absolute legal anarchy. We are witnessing a direct, irreconcilable conflict between the circuits. The Second Circuit ruled that New York's permit regime is unconstitutional and unenforceable. Simultaneously, the Ninth Circuit looked at Hawaii's virtually identical permit requirement and declared it perfectly legal. The First Circuit sided with Massachusetts, upholding their permits. The Fifth Circuit struck down similar requirements. This is not a legal system. It is a schizophrenic patchwork, where the constitutionality of your God-given rights depends entirely on your zip code. A permit system that is illegal in New York is somehow constitutional in California. This circuit split has frozen 47 other Second Amendment cases in the lower courts. Judges have explicitly stayed proceedings, writing that they are paralyzed until the Supreme Court clarifies whether permits are constitutional at all. One federal judge in Illinois wrote a scathing opinion calling the current state of Second Amendment jurisprudence incoherent and practically begged the High Court to intervene. The confusion is so profound that defendants in criminal cases are successfully arguing they couldn't possibly know if their conduct was illegal. Prosecutors are dropping charges rather than risking adverse precedent. But the engine driving this case isn't just about carry permits anymore. It has expanded to the unthinkable, the legality of basic ownership permits. The DOJ's kill shot, a request for 15 minutes of total war. The Department of Justice rarely asks to argue at the Supreme Court in cases where it isn't a direct party. But when they do, it is a signal that the heavy artillery is coming out. In the last 20 years, the DOJ has requested argument time in only 12 such cases. When they participate, the Supreme Court sides with their position 73% of the time. That statistic alone should send a shiver down the spine of every attorney general in a permit-requiring state. But here is the anomaly that screams danger. The DOJ requested 15 minutes of argument time. That is an eternity in Supreme Court time. Most amicus participants get 5, maybe 10 minutes. The DOJ is asking for enough runway to present a complete, independent constitutional theory. Legal analysts confirm that this signals the Solicitor General plans to argue a theory of the case that is likely broader and more aggressive than what the plaintiffs themselves are presenting. The Solicitor General's office has assigned 2 of their most lethal appellate attorneys to this file. Former Solicitor General Paul Clement described this level of involvement as extraordinary, noting that it signals the administration views this as a defining constitutional moment. Insiders report that the DOJ is conducting moot court sessions twice a week, preparing for every conceivable question the justices might fire at them. They are not playing for a tie. They are playing to establish a framework that governs the Second Amendment for generations. And hidden in a footnote of the DOJ's brief is a trapdoor that almost everyone missed, a suggestion that this ruling could redefine federal regulatory authority as well. The bureaucratic extinction event, 60 million hostages released. If the Supreme Court rules that permit requirements are unconstitutional, the practical impact will be nothing short of a bureaucratic apocalypse for the gun control industrial complex. 60 million Americans currently living under permit regimes would be liberated overnight. The 21 state bureaucracies that exist solely to process these permission slips employ approximately 8,000 government workers, whose jobs would become instantly obsolete. We are talking about the evaporation of over $400 million annually in state revenue extracted from gun owners through fees, processing charges, and mandatory training taxes. The market implications are staggering. Gun stores in permit states report that nearly 40% of potential sales are abandoned because customers simply cannot navigate the bureaucratic maze. Eliminate that friction, and the floodgates open. Industry estimates project an additional $3 to $5 billion in sales within the first year alone. Background check systems would face a tsunami of volume. Several states are already panic hiring staff to prepare for the surge. Firearms training businesses that rely on state-mandated courses could see 70% of their revenue vanish. But the angle that is being ignored is the federal licensing fallout. If states cannot require permits, the entire legal structure of how federal firearms licenses interact with state law begins to crumble. The desperation of the state, gaslighting the Supreme Court. The briefs filed by the states defending these permit systems reek of desperation. New Jersey submitted a 43-page document arguing that their permits aren't actually permits, but merely administrative procedures, a distinction without a difference. Massachusetts claims their system is about safety training, conveniently ignoring that you need government permission before you can even take the training. California's brief argues that permits are part of American tradition, yet they could only cite 3 historical examples, none of which even remotely resemble the modern, discretionary systems they enforce today. Hawaii submitted a brief that directly contradicts its own legislative history, claiming their permits aren't designed to reduce gun ownership, despite their own legislators explicitly stating that was the goal on the floor of the State House. New York's brief includes a humiliating footnote admitting they cannot identify any founding-era permit requirements, but then audaciously argues that the absence of evidence shouldn't matter. Maryland's Attorney General went fully rogue, suggesting that historical analysis itself is flawed, effectively asking the Supreme Court to abandon the Bruen framework entirely. Illinois hired 3 separate law firms to write their brief burning tax dollars to defend the indefensible. Even with that army of lawyers, they couldn't produce a coherent historical argument. Collectively, these states have incinerated over $12 million defending these systems in just this Supreme Court phase. They are so desperate they are citing foreign laws from Australia and the UK as justification, a tactic that is legally irrelevant in a U.S. constitutional case. And telling, not a single state could explain why constitutional carry states haven't dissolved into the bloodbath they predict will happen if permits are removed. The final countdown. June is D-Day. Oral arguments are locked in for late spring, likely April or May. The Supreme Court typically drops its constitutional atomic bombs in June, right before the summer recess. That means we are staring down the barrel of a final ruling approximately 6 months from now. If the court strikes down permits, do not expect a smooth transition. Expect absolute chaos. States will likely be granted a short grace period, 30 to 90 days, during which legislatures will scramble to pass new restrictions to replace the old ones. Justice Thomas has reportedly been prepping his line of questioning for weeks. He views this as the critical opportunity to cement the originalist methodology for the next century. The clerk of the court has scheduled extra time for this argument, a clear indicator that they expect a brawl. Anti-gun groups are already mobilizing, planning massive protests outside the steps of the court. What happens in the next 6 months will determine whether 80 years of unconstitutional permit requirements survive or collapse into dust. This decision will fundamentally alter the landscape of gun rights in America. You cannot afford to blink. Make sure you are subscribed with notifications on, because when this ruling drops, the world changes overnight. Drop a comment below. Which state are you in, and are you ready for the permit system to fall?